Hello and welcome back to Law Logical, your weekly guide to understanding the laws of the land in the most simplified yet comprehensive manner. In our ongoing series on the 18 stages of a civil suit under the Civil Procedure Code 1908, we have already covered the journey from institution to argument stage. Today, we bring to you the 13th stage, judgment, one of the most crucial phases in any civil suit. This is the moment when the judge delivers the final decision, determining the outcome of the case. So stay with us as we explore this stage in detail, including relevant provisions under CPC, judicial interpretations, and real-life examples from Indian court proceedings. In simple terms, a judgment is the court's final decision on the rights and liabilities of the parties in a civil suit. It contains the judge's reasoning, findings on issues framed earlier, and the final verdict. The judgment is pronounced under Order 20 of the Civil Procedure Code 1908, which lays down specific guidelines regarding its contents, delivery, and the time frame within which it should be pronounced. Let's now take a look at the legal provisions that govern the judgment stage. Section 33 of CPC. It mandates that the court shall pronounce judgment after the case has been heard. Order 20, Rule 1, specifies that the judgment must be pronounced within 30 days from the conclusion of the hearing, extendable to 60 days in exceptional cases. Order 20, Rule 2 and 3, states that the judgment must be clear, precise, and in writing, stating reasons for the court's decision. Judgments can be categorized into the following types. Declaratory judgment establishes the legal status or rights of a party without awarding damages. Final judgment concludes the suit entirely, leaving nothing more to be decided. Interim judgment, given at an intermediate stage, but does not conclude the entire suit. Ex parte judgment, issued in favor of one party when the other party fails to appear or contest. One famous example of an ex parte judgment is Malkiat Singh v. Yoginder Kaur, 1997, where the defendant did not appear and the court ruled solely on the plaintiff's submissions. A judgment is not just about who wins or loses. It reflects judicial reasoning and interpretation of law. A well-structured judgment must include the facts of the case, the issues framed, arguments from both parties, the court's reasoning and legal principles, and of course, the final verdict and relief granted. An improperly reasoned judgment can be challenged in appeal or even reviewed by the same court under certain conditions. To understand how judgments work in real cases, let's consider an example. In Kesavananda Bharati v. State of Kerala, back in 1973, the Supreme Court delivered a historic judgment defining the basic structure doctrine of the Constitution. The judgment was nearly 700 pages long, highlighting its significance and the depth of reasoning required in complex cases. This stage emphasizes the importance of a skilled advocate. A proficient lawyer ensures that all legal arguments are well documented, precedents and case laws are cited effectively, and the judgment is legally sound, leaving no room for ambiguity. A strong representation at this stage often influences the outcome of appeals and execution proceedings. And that concludes today's discussion on the judgment stage in civil suits. In our next episode, we will move on to the 14th stage, decree preparation and execution, where we will explore how the judgment is enforced. If you found this video helpful, like, share, and subscribe to Law Logical. Drop your questions in the comments below and we will answer them in upcoming videos. Thank you for watching. See you next time.